Hello and good afternoon, everybody. We're going to make a start now, so I hope you're ready and sitting comfortably. So a warm welcome to you all then, and thank you very much for joining us today. As always, we're going to start with a brief introduction, if I may, for those of you who perhaps haven't joined us before or haven't met us in person. So my name's Karen Faulkner and I'm the HR Knowledge Manager at HR Solutions, and I will be leading the presentation today. And I'm joined by my colleague, Ateem Arden, and she's here to field any technical problems that there might be. Hopefully, of course, there won't be any, but if you did have an issue, then please feel free to use a dialog box there to drop us a message and we'll see if we can support you with that. Now, hopefully I'll answer any questions you have as I go, but if there is any thing that you want clarifying at the end, please feel free to send me an email or drop me a message, and I'll look to get back to you as soon as I can. And as always, we are recording this webinar, so it will be available for you to watch again if there is anything you want to refer back to, and I can always send you a copy of the slides as well. So the structure of the webinar today then, so we are here to look at what subject access requests are going to look like under the GDPR. And as part of that, we're going to look at what's covered under the right of access, some of the practicalities that are going to be involved, the changes to timescales and fees, and ultimately then what we would have to do if we need to refuse a request. Okay. So this is a fairly succinct webinar, certainly compared to some of the other GDPR sessions that we've done. I would expect that we're going to look to finish at about 2:30, 2:40. Okay. So we will be starting then with the right of access. So what is covered? So, I mean, firstly, of course, the right of access or the right to make a subject access request is not new. So that's the first piece of good news. But certainly it's probably the most common area that HR professionals or employers in respect of their employees will tend to need to understand data protection laws, as it tends to be where HR crosses over the most. So, for those of you who aren't perhaps already aware then, this right is about enabling a data subject or an employee to have access to the personal data that we as employers might hold about them, okay? So if I do use the phrase employees, it's because we're talking in a HR context, but really we're looking at data subjects. So this does, of course, include workers, contractors, and any other persons that might, come into your organisation. Now, under the GDPR, we are informed that the right of access is something that should be very easy for an individual to invoke. Okay, and it's also something that we should be permitting at, quote, reasonable intervals. Okay, so there's nothing in the regulation which specifically says what is meant by a reasonable interval. Okay, certainly I think it would be fairly safe to say if somebody perhaps requested access to their absence records and 12 months later they asked for the same thing, I think it would be unreasonable for us to refuse that access or to put barriers in place. But perhaps if somebody was asking for information that they'd already received, a week or two later, that might start to be unreasonable. But I think we're always going to have to take circumstances into account. Now, under the GDPR, the regulation tells us that the reason or the purpose for this right is to allow data subjects to be aware of what personal data is actually being processed about them. Okay, so it's allowing them to be aware of what information we have on them, and it should enable them to verify that the way in which we are processing that data, okay, collecting it, processing it, storing it, getting rid of it, is done in a lawful way. Okay, so this means that technically a subject access request should be made in order to provide that awareness and in order for them to verify that we're handling their data lawfully. Okay, now I've not had anyone yet disagree that if we were to perhaps refuse somebody access because they didn't quite ask for access in the right way, you know, for example, we most commonly get somebody asking for access when they leave or as part of a grievance that might be coming up, you know, it might be unreasonable if they said they wanted certain details in respect of a grievance, you know, that they're raising, for us to say, oh, well, you've not relayed the fact that you just want to verify we're processing it lawfully. You know, I think this is a very academic awareness that I wanted you to have, but I think it's for us to understand that this is why the right exists, but essentially the emphasis is very much on transparency throughout the whole of the GDPR, and certainly we are going to look at the reasons for which you might be able to refuse a request a little bit later on. Now, we're quite familiar with arranging for an employee to be able to sit and view their personnel file or to provide them with a copy. Under the regulation that's effective in 25th of May, a subject can also ask to be provided with additional information. Okay, so we've got 9 points that we're going to be looking at here. So to start off with, they can ask to understand the purpose, okay, so the purpose for which we have collected and hold the personal data. Secondly, they can ask to understand the categories of personal data that is held about them, okay. Now, this is something that was probably going to be fairly self-evident, certainly if we have provided them with a copy of whatever it is they've asked for, but nonetheless it is written into the regulation that they can ask to be informed of the categories of personal data. Okay, so again, that's nothing more fancy than, say, absence details, disciplinary details, you know, grievance records, for example, you know, broad categories of personal data. So that would be that. Thirdly, the recipients of the data that we hold on them. Okay, so if any of you have been keen and have been watching my GDPR compliance series, hopefully you feel that this is a nice accompaniment to that. But certainly in the second episode that we did, which was on roles, we talked about the definition of recipients, and very, you know, briefly, as a definition is anyway, a recipient is just somebody who would have access to that personal data. Okay, so it could very easily be other employees. You know, certainly if you have HR admins, for example, who are likely to be able to view personal data about your employees, that would be an example of a recipient of that data. Next, they can ask to be told how long you intend to store that personal data for. Okay, now if you don't know what the set time period is, okay, then you ought to have criteria which will govern the thought process as to how long you will be keeping something for. So you should advise them of that instead. Okay, so if you haven't already, this is just another prompt to think about your retention periods. The fifth thing that we need to be aware of is, for example, if somebody said, you know, as part of their request that they don't really understand their rights in respect of data, we would need to inform them that they have a statutory right to request that their personal data is updated, okay, so the right to rectification, that they have the right to erasure, and that they have the right to have processing restricted, okay, in some way. So these may not always apply in every circumstance, but these are statutory rights that all data subjects, you know, so that includes you and I as individuals, would have. So as an organisation, if you ever had this right invoked, it is well worth checking whether or not the situation is applicable. And then the last few, so equally, you would need to advise this person that they have a right to lodge a complaint, okay? So if perhaps they were to feel as part of their request that there was something they were concerned about the lawfulness of processing, so that might, you know, if you remember the principles of GDPR include that you're keeping more information than you need, you know, for a purpose, then they should be informed that they have the right to lodge a complaint about that with the relevant supervisory authority. So for many organisations that are based in the UK, that is going to be the Information Commissioner's Office or the ICO. Number 7, you would need to let them know the source of the personal data if you collected the data from someone other than themselves directly. Okay, so this is something that might be something that crops up in respect of references, for example, in terms of HR. Next up, you would need to inform them of any details of automated decision making. Okay, so when we talk about automated decision making or automated processing, I find it easier just to quickly explain what is meant by that by giving an example. It's not HR specific, I'm afraid, but if you were, say, applying for a credit card, you might be faced with, you know, a series of fields, a series of questions on an online system that you would fill in, and without any human intervention, it would automatically generate a decision as to whether or not you qualify for a card and perhaps the limit on that as well. Okay, so that would be an example of automated decision making. I think it's very rare that this is something that's going to come up in HR, certainly without any human intervention, because usually when we're looking to make any serious decisions about somebody, we tend to have, say, an investigation meeting or a catch-up of some sort, okay? Something you might want to think about in terms of recruitment, if you have any fields that might automatically discount someone from an application. And it might be worth suggesting to individuals that if they disagree, perhaps with a decision, that they can get in contact with you. And last but not least then, if you were to be transferring any personal data whatsoever internationally, okay, and remember that this can mean even storing data on servers that are based internationally. If you are relying on your own safeguards that you've put into place in order to make that international transfer lawful, then you may be required to advise the data subject of what those safeguards are. So, what are the practicalities of this on a day-to-day basis? What is this going to look like? Well, I've already mentioned that we're told requests should be permitted at reasonable intervals, okay? We're also told very explicitly that a copy must be provided of the documents or information that is asked for, okay? Now, wherever somebody should put in a request by electronic means, the regulation specifically says that we must also respond to that request electronically, okay? So probably in layman's terms, this just means if somebody emails you a request for information, we might email them back, okay? Perhaps just make sure that that email is going to be secure. Perhaps you password protect the file or send it encrypted or something like that. And the regulation also asks us that wherever possible, okay, that we arrange for a data subject to have remote access to their personal data in order to view it and gain this access, okay? So it is wherever possible. You know, it might be that this would attract a cost, but do remember that the GDPR specifically says that we should be using state-of-the-art technologies and processes and systems wherever possible. Okay, so as far as we can reasonably afford it, we would need to look to make arrangements. Perhaps you even already have the facilities in place and they just need activating, but we would need to make arrangements to achieve this. Okay, so for example, what this might look like is that an employee is perhaps able to log in to a relevant system from the comfort of their own home, using a secure server to view the personal data that you hold on them. It's quite likely that a reason that they're looking to promote this is because if you think about an information system, for example, an employee database, it may well be that the way in which you name the fields, okay, or any notes that you might upload against their data. For example, if there are any leaves of absence, you might be putting, notes to yourself there on that. Those notes or the way in which we word the headings might have an inference on the information that's been updated, okay? And we are required to ensure that all the data that we keep is accurate and up to date, okay? So if a data subject is able to see their data in its natural habitat, so to speak, where you keep it on a day-to-day basis, this is likely to help inform them that that is being kept in a way that is accurate for any recipients that might view that data. So what might you have to do? Well, if you are particularly robust in your organisation and you have a set policy for subject access requests, then it might well be worth you revising that policy. Okay, and equally, if you perhaps have a suite of template letters, then you are going to need to revise those too. If you perhaps wanted to use ours, then you might be able to contact us with regards to that. And you're also going to need to ensure that you have clear processes, okay, certainly because there are going to be shorter timescales, which we're going to look at. And so you're going to need to be feeling confident that you can comply with a request, particularly if you get a complex or nasty request. Let's face it, we rarely have an employee who asks for this when everything's hunky-dory. It's normally when there is a grievance or a contentious resignation. So you want to ensure that you are being efficient and almost not giving other grounds for them, to be able to make a complaint in terms of data protection compliance. So you might need to just ensure that everybody knows who would be responsible for handling a request and that they know exactly how to deal with that as well. And a question that's often asked, is, will I have to provide information? Because sometimes many of our letters and documents or forms and things might have details about others on there, or they might be particularly private or sensitive business documents. So in Recital 63, if you wanted to look it up, it does talk about the fact that this right of access, okay, where we have got to allow it and it's got to be easy for people to do, by adhering to it, it shouldn't adversely affect the rights and freedoms of others, and it should not affect trade secrets or intellectual property either. Okay, so this is the wording lifted straight out of the regulation. In terms of how you manage that, you might consider whether or not of the information that's been asked for, can you extract any of the details, or can you redact any of the information? Okay, so literally that might mean taking a really thick black marker and striking through personal details of others, while still providing pretty much the rest of the document as a whole. Okay. And again, the regulation does specifically say, I'm afraid, that if either of these two situations should apply, okay, it would not give a data controller or an employer the automatic right to just refuse outright the request, okay. You're certainly going to have to still try and provide as much of the information asked for as possible, okay. Now, just to give you a further example about this latter one, the trade secrets and intellectual property, and I must stress that this guidance I'm going to reference is from the Information Commissioner's Officer, but it's in relation to the Data Protection Act 98. Okay, so this is very soon going to be outdated advice, okay, but within that code of practice that they have issued, their guidance. they do discuss an example of a redundancy rationale, okay, that might be being drafted and has not yet been communicated to the organisation or the individuals who are at risk, okay. If somebody were to make a subject access request, and they could make a broad request, you know, for any documents or information where their personal data appears, and you know that their name appears in this drafted redundancy rationale, okay, you would not necessarily be expected to disclose that rationale, okay, because that is going to adversely affect, you know, your organisation. So again, I must stress that's an example in relation to the old legislation that we have, but hopefully it is a bit of an indicator that really highly sensitive documentation like that may be exempt, but I would certainly look to get advice, okay, before you decide of your own accord to refuse to give anything that you think might be sensitive. So moving on then, timescales. What has changed? Many of you may be familiar with the round number 40 days to comply with an access request, okay? Well, going forwards, this has changed quite significantly, actually, because the overriding emphasis is on the fact that we must comply with a subject access request without undue delay. Okay, so as soon as possible, and within 1 month at the absolute latest. Okay, so that's the maximum length of time that we would have to comply with a subject access request now. Okay, so it is quite significantly shorter than the 40 days. It's perhaps noteworthy that, you know, this doesn't say 30 days, it doesn't say 28 days, it doesn't say 31 days, it says 1 month, okay? So perhaps if you received a request at the beginning of February, you'd have less time to deal with it, you know, than if you got a request on the 31st of January, let's say. So be conscious of that, but I think, you know, certainly it just perhaps again goes to demonstrate the emphasis on this first participle, that we've got to comply without undue delay. Okay, so minor factors such as, is it 28, 29, 30, 31 days is, you know, here and there, we've got to do it as soon as possible. But what if we can't? Okay, there's always an exception to the rule, isn't there? And I can't stress this enough. Okay, although I have put this in here for your awareness, it is very clear that the regulation expects this to be an incredibly rare situation. Okay, this is really exceptional circumstances. Okay, you're almost going to have to document the business reasons why you were not able to adhere to this timescale. Okay, and you've got to be prepared. I know it sounds probably far off, but you might as well play devil's advocate. If you were in front of a judge, are you going to feel confident telling a judge the reason why you extended the timescales? Now, if you do need to, then you are allowed to extend it by a further 2 months if necessary. Okay, so yes, that does mean a total of 3 months maximum time within which you potentially could have to comply with a request. Okay, but again, it's not that if you need to extend the timescales, you can just latch 2 months onto the end. You've got to decide how quickly you can deal with it and latch the appropriate amount of time onto the end, up to a maximum of an extra 2 months. Okay. And the advice in the regulation is that you decide how long that should be by taking into account the complexity of the requests, okay? And you can take into account the number of requests as well, but these are the things that they would expect you to be considering rather than, say, any other business commitments that you might have going on, I'm afraid, okay? And if you do apply an extension, okay, you have got to tell the data subject within the first month of the receipt of that request. Okay, So it would be no good getting to the end of that month, and the next day letting them know that actually you want to use this caveat to be able to extend to 2 months. It would be too late, okay? You really ought to be aware of how long it is going to take you to adhere to this request, have good justification for that, and have advised the data subject within that first month of them putting in the request. Okay. Now I'm going to come back to this text in pink, okay, and the things it wants you to consider. So just put a pin in that for me for now, and we're going to revisit why you may struggle to rely on that a little bit. Right, so fees. So one of the major things that changed was the timescales. We've lost the 40 days. That's reduced to ASAP/within a month at the latest. Fees. We're used to being able to charge a £10 administration fee, which, can help if you perhaps are paying anybody in the office by the hour and you do have a cumbersome request. You might be able to cover, the fee of the man hours there, or it might be a good way in which you can put somebody off a request that's perhaps not very sincere. Can you charge a fee going forwards? Well, no, I'm afraid not. Okay, from the 25th of May, when the GDPR is enforceable, it will no longer be lawful to charge a fee. Okay. Which is akin really to the fact that the right says it should be easy to make a subject access request. Putting a barrier in place like arranging payment is a barrier. So no, we cannot be charging fees for subject access request unless one of these exceptions apply. Okay, so yes, again, we do have another case where there is an exception. So if additional copies of information have already been provided and are requested again, okay? If this is the case, then you may charge a reasonable fee. I wanted to remind you that you should be permitting access requests at reasonable intervals, okay? So it doesn't actually say this anywhere specifically in the regulation, but my interpretation would be, okay, that because we should be allowing access at reasonable intervals, it may be unreasonable to charge a fee for a repeat request sometime later. That's my opinion. For example, if somebody wanted access to their absence records, and 12 months later they're asking for the same details, is it going to be transparent and easy for them to access it if you're then saying, oh, hang on, I can see here 12 months ago you asked for that? I think that would be unreasonable. I think the ICO might take a dim view. So I would probably only look to be charging a fee if somebody asks for exactly the same information again, which you have already provided and you did it fairly recently, within a few weeks or a few months, for example. And you may also charge a fee. Okay, you may also charge a fee if the request is considered to be, quote, manifestly unfounded or excessive. Okay. Now, where I asked you just to put a pin in it on the previous slides, I just want to refer back to this. Okay, so we have got previous case law which does suggest that it's going to be very rare that a judge is ever going to agree that an access request would fit this description. Okay. Equally then, in terms of when we decide timescales, how complex is the request, how many requests are we having to deal with? I do recall a case where, as part of tribunal action, I think almost hundreds of employees were making access requests at the same time, and it was not held to be reasonable, okay, that the employer was not able to comply as expected. So at least based on what we've got at the moment, I do think you should really avoid reaching the conclusion of your own accord, at least, that a request might be manifestly unfounded or could be excessive in its nature. Again, I would just strongly suggest you perhaps contact the ICO. You know, they do have a free phone number, so why not put the question to them and document the advice they give you. So we're told it's a reasonable fee. What does that mean? Well, you know, let's take inference from previous laws. It's how we tend to operate when we're looking at laws that have changed. So the GDPR doesn't say what a reasonable fee is, okay, but of course we do know that previously we could charge anywhere up to a maximum fee of £10, okay, so less than or equal to £10 I would suggest is a guide. And as always, it's probably going to be something that we judge on the circumstances. Okay, so the size of your business, how easy it is going to be for you to allocate time to adhere to the request, the circumstances of the individual, you know, financially is something that we might need to be taking into account as well. So lastly then, what are the situations in which you can refuse a request? Okay, these are limited, but you should definitely refuse a request if it's not possible for you to identify the data subject, okay, who is making the request. It goes without saying, GDPR is all about data protection, and you know it emphasizes hugely the importance of us being accountable for security and the privacy of data. So if we don't know who is asking for details, of course we should not comply with that request, you know. Now we must make sure that we are making reasonable attempts to verify the identity before refusing. Okay, so refusal should not be something that we jump to. So we should try and attempt to identify somebody positively. And as always with the GDPR, you know, if you are going to have to ask for additional personal details, additional personal data in order to be able to verify somebody's identity, then please just make sure that what you are asking for is restricted to what's absolutely necessary, you know, to be able to identify that person. Okay, so try and avoid asking for something that might be sensitive or special category data if possible. Okay. Now responsibility is going to be on the employer or the data controller to demonstrate that they were not in a position to identify the data subject. Okay, so again, the emphasis is on you to make those attempts and to document any decision to refuse a request and the reasons why. Okay. Now, I imagine in terms of HR and employers, it's probably only going to be something that's a problem for us. You know, if we've got perhaps an ex-employee who's making a request, you know, particularly if they do it via letter or email, you know, could be husband, wife, sister, worst enemy trying to access their personal data. So it's well worth you perhaps using another known, if possible, form of communication to contact them and verify who they are. New managers might not be able to recognise someone's voice, you know, so we'll just need to think about how it would be appropriate to try and verify someone's identity. Perhaps just put yourselves in the shoes of somebody who finds out another person was trying to access your data. You know, what steps would you have hoped your ex-employer would take to verify who you are? And you may refuse a request, this wording again, if it is manifestly unfounded or excessive. Okay, so if you think that this definition is met, your options are either to A, charge a fee, or B, refuse the request. Okay, but again, as I said before, please do take extreme caution before deciding to refuse to adhere to a request outright for this reason. Okay, this is going to be the most risky situation when you decide to outright refuse a request on the basis that you think that the request is perhaps unreasonable or illegitimate or excessive. Okay. So if we do refuse a request, if you do decide that you are not going to comply with a request for access, okay, then you must inform the employee or the data subject within 1 month at the very latest, but again, you should be telling them without undue delay. Okay, so again, if you weren't sure of identity, for example, it's going to have to become a priority to try and work out who that individual is. Don't leave it to the last minute, because then not only have you got to work out who they are, but you've then got to adhere to the request, maybe even redact information and so on and so forth within that time. Okay, and I'm afraid that you must also inform them of the possibility that they can lodge a complaint for your refusal to adhere to the request, okay, with the relevant supervisory authority, so most likely the ICO. Okay, so if you do ever write back to somebody, or you're informing them that you aren't going to adhere to the request, you would need to do it ASAP, within 1 month at the latest, and you must include the information that they are allowed to lodge a complaint with regards to your decision. Okay, so again, all the more reason for you to be certain that you're doing the right thing in the first place. And another prompt's just to review your template letters, if you have them. So that is it. Okay, that is the GDPR on subject access requests. Now, if I haven't perhaps answered any questions you have during the course of this session, please do feel free to get in touch with me, and I'll look to come back to you as soon as I can. Equally, if you did have any feedback, good or bad, I don't mind. I've got thick skin. Please let me know. I'd be happy to hear from you on any ways in which we can adapt this to suit your needs. Have a look at our website. We've got lots of interesting stuff coming up. It gets updated very regularly. So if you would like to come along to anything in person, we've got some seminars, for example, on employment law for the year ahead. Have a look and see if you'd like to join us. So here we are then. Thank you for joining me on this session today. I do hope that that was helpful and informative, and perhaps we will see you again next time. Thank you, and bye-bye.